So today we have taken this topic of bail law in India. And why it is in news? Why it was in news? Because there was an observation made by two judge bench Supreme Court, and they have analyzed that there is a pressing need for reform in the law related to bail, and they have called on the government to consider framing a special legislation on the lines of the law which is there in United Kingdom. So the observation was made by two judge bench comprising Justice Sanjay Kishan Kaul, as you can see the name below their images, and Justice M. Sundaresh. So they issued this clarification when they were analyzing the older judgment which was delivered in July 2021, that is last year, exactly 1 year back. And that judgment was about bail reform, and the case name was Satendra Kumar Antil versus CBI case. So remember this. Okay. So that's why the bail law and Supreme Court call for reform. This was in news, and it is a news of July 13 itself. So what was the observation made by Supreme Court? The observation which was made by Supreme Court was that we are a democratic country, we are in democracy, and we cannot give this impression that we are police state, because democracy and police state both are conceptually opposite to each other. Okay, so we should be guided by democratic features, democratic principles, and values. Next, they have also highlighted that arrest, when we arrest someone, so arrest per se is a draconian measure which results in curtailing the liberty, curtailment of liberty, and if that is the case, then it should be used sparingly, it should be used rarely, it should not be the norm. Okay, so we have to use it in as and when it is required. Next, they have analyzed that since the rate of convictions in criminal cases is very low, so we have low conviction rates in criminal cases in India, thus bail applications are regarded in a negative sense. Also, they have highlighted that criminal courts in general, with the trial court in particular, are the guardians of liberty. They are guardian angels of liberty, be it the criminal court or the trial court. They are the guardians of liberty. So liberty, if we analyze liberty as embedded in the code, has to be preserved, should be protected and enforced. So focus on liberty aspect. So that is one of the important value. So that is what they are analyzing, and that's why it was in news, and that is the observation of the judges with respect to democracy, with respect to arrest, with respect to liberty, with respect to low conviction rate, and why bail is considered as in negative sense. And thus we need to have a reform. That's why they are saying that pressing need of reform is there on the lines of bail laws as it is there in UK. So that is why it was in news. Let's analyze it further. So the Supreme Court has also analyzed, they have also said that the bail application should be disposed of within 2 weeks, 2 weeks of application, except when provision itself is mandating otherwise, while pleas for anticipatory bail be decided within 6 weeks. Okay, so in other cases, that is the scenario. Otherwise, the bail application should be disposed of within 2 weeks, except when provisions are mandating it otherwise. Okay. Next, they have also analyzed the role of magistrates. So they are saying, according to various sections which deal with various stages of trial, where a magistrate can decide on the release of the accused. So magistrate can decide, and here magistrate must routinely consider granting bail without insisting on a separate bail application. So while you are analyzing under the different courts at the different stages of trial, it is the responsibility, it is the role of the magistrate to analyze it, routinely consider the granting of the bail, and don't insist for a separate bail application. Also, the court has directed the high courts to undertake the exercise of finding out the under trial prisoners, to find out the status of the under trial prisoners who are not able to comply with the bail condition, so that appropriate steps can be taken under the law and can be taken for their release. So this is what the Supreme Court has analyzed and they have observed, and that's why it is in news. Okay. So there was a judgment in 2014. Arnesh Kumar judgment is there. So that judgment had directed cops to diligently record specific reasons for the arrest, and they also directed magistrate to grant bails. So this judgment is very important. Not only that, they have also told that if the reasons are not persuasive, Okay, so disciplinary action must be taken against the officer, be it in police, judiciary, or executive. Okay, so disciplinary action should be taken against the officers if the case is not persuasive, reasons are not persuasive. Also, this particular judgment is talking about setting up the special courts for related to these bail aspect. Okay, so this is one judgment which has set a context, and we should know this for our answer writing. Now let's analyze it further. Now let's understand the current legislation on bail, which is there. So what is the status? So if we have CRPC, and under CRPC, the word bail is not explicitly defined, and it has just listed offenses which has categorized either as bailable or non-bailable as according to the Indian Penal Code. Okay. Next we have this provision that for bailable offense, magistrates are empowered by CRPC to grant bail to the application as a matter of right, meaning that if the applicant can be released upon furnishing a legitimate bail bond. So for bailable offense, it is their matter of right, and magistrate should consider that. So that provision is there. And with respect to non-bailable offences, police, if they are enabled to arrest without warrant also. After which a magistrate will determine whether to release the accused on bail or not. So magistrate will decide in the cases of non-bailable offense, and in bailable offense, it is the matter of their right if they are able to furnish legitimate bail bond. So these are the provisions. So with respect to bailable offense, it is mentioned under section 436 of the CRPC in 1973. With respect to non-bailable, where magistrate is going to take care of things, then section 437 of CRPC 1973 is talking about that. So we have this with respect to current law, current legislation on the bail. Now let's analyze the bail law in India and what are the needs for reform. So the needs are that the first argument which you have to give is with respect to the under trial population. So we have huge pendency of under trials. Almost over 76% in 2022 is the data that over 76% of the cases were under trial, and these are unnecessary arrest coupled with no bail is a double jeopardy for them. So it shows the slow wheels of justice. Around 4 crore cases in lower courts are pending. So when pendency is so high, when pendency of the cases are there, and under trial population is already very heavy, so then why we are not considering about bails? And that is unnecessary burden on the jail infrastructure as well, jail authorities also. And also, it is leading to the problem of overcrowding. Unnecessary arrests are there. We are not giving bail. So, if we analyze, there is a data that in the North Indian jails, occupancy rate is 177%. So, will it not be burden? And don't you think that it is going to create other ancillary set of problems of hygiene, food, harassment in within jails? So there are set of, so if you know that what was the status of Tihar jail when Kiran Bedi ma'am took over it. So like this problems will be there. So overcrowding comes with another set of problems. Okay. And also, it is a matter of colonial legacy because magistrates who are ignoring this bail, so basically for them the rule is jail, not bail, and this reflects the colonial mindset because CRPC was drafted in 1882 and it continues to be in use. So this is the problem. So that's why we need reforms. Other arguments which we can have for need of reforms is related to inequity. So inequity in accessing the legal system. So we know that police is very quick in arresting people, arresting citizen, and this puts especially people from vulnerable section, that is poor people or women, illiterate people, into a very bad situation or a disadvantageous situation, as police is taking the advantage of their system, their situation, and these poor people, vulnerable people, they are unable to take the advantage of the legal system, unlike those who are educated or affluent or those who have influence. So they cannot avail these facilities. First of all, they are not aware of it, and second is that they cannot furnish bail bonds. So this issue of inequity was also highlighted by 268th report of law commission. Next argument which you can give is with respect to lack of clarity. So there is lack of clarity with respect to judicial proper judicial clarity in bail matters is not there. For example, we had this case, INX Media case. So here the bail application of P. Chidambaram, whose name was not registered in the FIR, was denied, whereas his son Karti, the one who was accused in FIR, was granted a bail. So these orders indicate vagueness, inconsistencies. So what we can say? We can say that there is lack of proper judicial clarity in these matters. Next is with respect to indiscriminate arrests. So we have this culture of too many arrests, especially for non-cognizable offenses, which is unwarranted. And majority may not be even required. The majority of the arrest may not be even required because despite the registration of the cognizable offense, so arrest may not be required at all, but we are registering. So there is no clarity in which cases to have, which not. So we have this culture, let's arrest people. Maybe I don't know, movies से इंस्पायर होते हैं कि कैसे इंस्पायर होते हैं. So we have this culture, too many arrests are there, especially in the non cognizable offenses, which is not required at all. So, in this regard, as the Supreme Court has also highlighted, the reform should be on the lines of the laws which are there in UK. So, the Bail Act of United Kingdom 1976. So, the name is the Bail Act of United Kingdom. So, they have a separate act itself, Bail Act of United Kingdom 1976. So, it prescribes the procedure for granting bail. So, whenever you are writing this as a case study, or when Supreme Court itself has highlighted it, so remember the name. So, this Bail Act of United Kingdom 1976 have so many features which should be there. So the one of the key feature is that, and it aims that this legislation should come because we should focus on reducing the size of the inmate population in the jail so that there is no burden. So our objective should be reducing the inmate population. And also the law has provision for ensuring legal aid for defendants. So those who want legal aid, it should be provided to them. And where they can have the accessibility, not only on paper, the legal aid should be provided to them so that they can fight for their rights. And this act recognizes bail as a general right to be given to the inmates. So it is their right, and this recognition has been given in this particular Bail Act of United Kingdom 1976. Also, with respect to rejection of the bail, this act is saying for rejecting bail, the prosecution must show the grounds which exist for believing the defendant on bail would not surrender to the custody or would commit an offense while on bail. Okay. So, would commit an offense while on bail or would interfere with the witness or whatever. So, you need to specify the grounds that why the bail application should be rejected. So, these are the important features which you should keep in mind. Okay. So, keeping that in mind, whatever has been suggested by Supreme Court or the UK laws are there. So, on those lines, so what direction has been given by court in this direction in the recent judgment is that there has to be a separate law for bail should be there, because we have seen that how unnecessary arrests are happening. There is no predictability, there is no protection to the undertrials. The population of undertrial is huge, and it is creating a burden on the jail authorities as well. So this is one. They have also talking about that a separate bail law should be there because it will give uniformity and certainty. As of now, there is no uniformity and certainty in the court decisions. So, for few magistrates, jail is norm, but actually it should be bail is the norm. So, they are dependent upon the mercy of the magistrates, their whims, their fancies, that how they want. Okay, so what is their mood, how are they in on particular day, what is their mood, so they will decide. So the under trials, the people, the inmates, they are dependent upon their mercy. The third direction which has been given is that person accused of to same offense must be treated alike. So what is happening, we have seen that sometimes we have rich versus poor, has versus have not. So rich people, they can afford bail bond, but the poor people, they cannot afford bail bond, so they cannot fulfill those obligations. So based on the economic capacity also, these things are happening. Bail is being granted or is not being granted. So two people accused, two-person accused to same offense must be treated alike. Next direction which has been given by Supreme Court is that this direction has been given to states and UTs that the states and UTs should give direction to their police that they should not go for any unnecessary arrest. So they are telling that police should avoid indiscriminate arrest. They must be directed to not go for indiscriminate arrest. So these are very important observation which has been given by the Supreme Court in the recent judgment. Now let's have a look at way forward. So when we are talking about bail law in India, so way forward, what you can write is this case which we discussed about Satendra Kumar Antil versus CBI in 2021. So they recommended certain things which has not been implemented till now. So they told that there should be there are three categories of offenses. Okay, and these categories are based on imprisonment. So we have category A, then we have category B and D together, then category C. So what are these categories? We will discuss. So under category A, those offences come under category A, which where the imprisonment is less than 7 year offence is there, or less than 7 year. Okay, so like police cases are there. So in such cases, someone should be issued. If magistrate is issuing a summon for, then the accused has to come physically. They have to appear physically. Then magistrate will decide whether bail should be given or not. If the accused is not appearing physically, then magistrate will issue a bailable warrant. And after that bailable warrant, also, if the accused is not coming physically present, if it is not physically present, then non-bailable warrant will be issued against the accused. So, what will happen in non-bailable warrant? Finally, arrest will be done, and the accused has to come physically. So when at that time, if accused is coming and they are applying for the bail, in such cases, magistrate will either decide on merit or will give interim bail till the court is deciding the matter. So this is how in the cases related to category A, the bail is being decided by the magistrate. This is the whole process which has been explained on the screen. Then other matters where category B and category D offenses are there. So category B offenses are those offenses where the imprisonment, the punishment is more than 7 years. It can also include death punishments or life imprisonment. So it is related to that. So in those cases, in category B cases, accused will go to the court and their magistrate will decide. They will apply for the bail. So magistrate will decide on the merit whether bail has to be given or not. So this is with respect to category B. Category D is also related to economic offenses under special acts. Okay, so the those special act has directions, they have provisions how the bail should be given. So magistrate is not doing anything, they are just following the provisions of the special act, and they are accordingly they are giving the direction related to bail. And the last category, that is category C, is a category where the serious crimes, the crimes of serious in nature, they are covered, like Narcotics Act, under Narcotics Act, or PMLA Act, or UAPA, unlawful UAPA Act is there. So under that, if any crime is there, so that comes under category C. So here how the bail will be decided? So here bail, these particular acts have provisions. So here most of the time jail becomes norm and bail is exception. So the bail provisions are very rigid, very strict, and magistrate will decide according to the act whether the bail has to be given or not. Okay, so these provisions, the three categories of offenses, and how what should be done with respect to different categories of offenses, how to grant, how to give bail. Satendra Kumar until versus CBI judgment has discussed about it, and they told they have given the direction to the trial court and high court that this should be followed. So this can be a good way forward when you are suggesting that what we can do with respect to bail reforms in India, because this has been not implemented yet. And also definitely whatever we have discussed on the previous slide, or the in the whole issue that indiscriminate arrest should be avoided, we should have a separate law on the lines of UK. So those reforms also you can suggest as a conclusion or as a way forward. So this is it with today's discussion. Hope you all enjoyed the discussion. These issues are a bit technical in nature. Most of the time we don't get interest because we think it is hard, it is difficult to understand. So hope we have done justice to that, and we have tried to explain it in a simple manner that what kind of reforms we are talking about, why we are talking about, and what is the suggestion and what should be done. So we should never underestimate any topic, never judge any topic, because UPSC can ask anything. Even if they are not asking, you can take the help of these points to write or to justify your answers. Okay, so have a good weekend. We will meet on Monday, and enjoy your studies. Do proper revision and take care of your studies. If any problem, do reach out to us. We will help you. Okay, guys, take care. Enjoy. Study well.